The House Criminal Justice Committee will come to order. Our next order of business is to vote on substitutes for House Bills 4191, 4192, 4193, and 4194. The committee members will recall that we took testimony on these bills way back before break on March 21st. Okay, we do have a couple of cards to read in. Peter Rourke from the Michigan League for Public Policy supports the bills, does not wish to speak. Joe Haveman from the Hope Network, no connection there, supports 4191, 4192, and 4193, does not wish to speak. And then Judy Karangeff from the League of Women Voters supports the bills, does not wish to speak. I'll take a motion to adopt the H1 substitute to 4191. Representative Devendorf moves. Madam Clerk, will you please call the roll, or the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Aye. Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute to House Bill 4191 is adopted.
Thank you. I will now take a motion to adopt the H1 substitute for HB 4192. Would you please call the vote? Oh, I messed up. I'm sorry. I will now take a motion to report 4191 with recommendation as substitute H1. Would you please call the vote, Madam Clerk? So moved by Representative Breen. This is only the second bill we've moved out of committee, so I beg your indulgence here.
To report House Bill 4191 with recommendation as substitute H1, Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4191 is reported with recommendation as substitute H1.
Thank you. I'll now take a motion to adopt this H1 substitute. I'm doing a terrible job this morning. Apparently I haven't paid attention in any of my committees over the last 5 years. I will now take a motion to adopt the H1 substitute to HB 4192. Representative Breen moves. Would the clerk please call the roll?
To adopt the substitute H1, Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion to report HB 4192 with recommendation as substitute H1. Madam Clerk, will you please call the vote? Moved by Representative Arbit.
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Begol.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4192 is reported with recommendation as substitute H1.
Thank you. I will now take a motion to adopt the H1 substitute to HB 4193. Representative Devendorf?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Begol.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. Substitute H1 to House Bill 4193 is adopted.
Thank you. I will now take a motion to report HB 4193 with recommendation as substitute H1. Representative Breen moves. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4193 is reported with recommendation as substitute H1.
Thank you. I'll now take a motion to adopt the H1 substitute to HB 4194. Representative Carter moves. Madam Clerk, would you please call the vote? Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagul.
Yes.
Madam Chair, you have 13 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. And now I'll take a motion to report HB 4194 with recommendation as substitute H1. Moved by Representative Breen. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Aye.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
Pass.
Harris.
Pass.
Bagul.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. House Bill 4194 is reported with recommendation as substitute H1.
Thank you. And now we will hear testimony on House Bill 4173. Representative Ayash, Representative Meerman, go ahead and get started whenever you're ready.
Thank you, Chair. If it's okay with you, I'd like to invite up Joe and Barb. Oh, they got here.
Absolutely. Would you mind introducing them or having them introduce themselves?
Yeah, go ahead.
Joe Haveman from Hope Network.
Barbara Levine. I have a history of involvement with the Criminal Justice Policy Commission. So,
And there's no affiliation with you, Madam Chair, so. Okay, good morning, colleagues. Thank you all for taking up this bill, House Bill 4173. I just wanted to, before I start talking about the bill, I just wanted to let folks know that we will be working on this bill and that it will become 2 bills. So some mitosis will be happening with the legislation, which is why Representative Meerman is here, because this is an issue that we're both passionate about and we've worked on together. So, in summary, House Bill 4173 will create a 19-member sentencing commission, and the task is going to be lofty, which is why we need experts at the table to address some of the issues regarding collecting, analyzing, and disseminating information on state and local sentencing and release policies. So, the commission will have 5 main principal focuses. Number 1, researching the effectiveness of guidelines as it provides for public safety, reducing sentencing disparities beyond offense characteristics, and ensuring proportionality to the seriousness of the offense. It will also cooperate with MDOC, the Michigan Department of Corrections, to make projections regarding population capacity in state prisons, the impact of our sentencing guidelines, and the effectiveness of the efforts to reduce recidivism. It will cooperate with the state court administrator to collect data on the effect of sentencing guidelines on the caseload, docket flow, and case backlog of trial and appellate courts. It'll submit annual reports to the Michigan legislature on the implementation of legislative policies affecting the CJ system, and it will submit policy recommendations affecting sentencing and the use and length of incarceration on the legislature for the legislature's consideration. And I want to emphasize what the commission will not do. The commission will not make any recommendations that will retroactively affect existing sentences that have already been imposed. This is simply for future recommendations for sentences. And it will also not make recommendations affecting behavioral or programming credits, for example, like the good time credits. So that's a quick summary of what the bill does, and I will pass it along, if it's okay with you, Madam Chair, for any questions.
We do have a question from Representative Filler.
Sure. So in Michigan, we've had the Pew Task Force. We have MDOC, which has lowered recidivism down to lowest rate of prisoners since the 80s. We have treatment courts, which are remarkably effective and popular. I guess my question is, why would we need another layer of bureaucracy telling us what needs to happen in the justice system?
Well, thank you for the question, Representative. We haven't had a sentencing commission in over 30 years, and nearly every other state has one. And although that's not a reason to do it, just because nearly every other state has one, I think it's important that we recognize the gravity of what putting someone in prison means. It's an expensive, serious undertaking by the state, and it's something that we should have experts look at. You know, I'm certainly not somebody that can give you the best recommendations in terms of all the technicalities and what would and wouldn't make sense for making some of these cases. But if you look at sort of what's happened in the last 30 years, for example, just to give you a quick example around the way we view drug crimes and folks who have experienced mental health episodes, you know, one would argue that we probably have to reassess how we're addressing some of those issues. And if you look at something like domestic violence, you know, it was not something that 30 years ago, I think the punishment fit the level of severity of that crime. So quite frankly, you know, this is the best way to try to simply allow the legislature to lean on the experts. You lean on victim advocates, you lean on folks in the incarceral system, and you look at folks who deal with these situations every single day. You know, this 19-person commission would help work through all of those things from the experts that are dealing with this all the time.
And a quick follow-up, you don't believe that that's being done right now?
No. Not in the centralized way that we
not by MSP, not by corrections.
So this would centralize it and bring
by
all
SCAO.
This would bring all stakeholders to have expert discussions, to do research, and just simply lay out the information that's necessary for the legislature to then look at and say, is this something that would make sense for us to review? Is this something that would make sense for us to re-examine? You know, this really just allows the mechanism to bring all stakeholders to the table in a formal setting to really address it and lean on the experts and lean on the research to figure this out. I think, to your point, Representative, a lot of this is happening in fragmented pieces, and allowing us to be able to bring everybody together would provide for, I think, a more efficient way to address some of the sentencing guidelines in the state.
We do have more questions, but before we move on, I did want to mention, and my apologies, Carl Reynolds from the from the Council of State Governments Justice Center. He is the senior legal and policy advisor, and he is on Zoom. Representative Young.
Thank you. Thank you for your testimony. Thank you for the work on this. I just had a couple of questions as it relates to how the members are being selected. What I found throughout the bill is it says from a list of 3 names submitted by some entity or organization. But then there are a couple of places where it doesn't do that. One individual who was previously incarcerated and one individual who represents Community Correction Agency. So I'm just curious, how are these single one individuals being selected? Because it's clear how the others are being selected, and why don't we have an option of 3? And what comes to mind is, because we know in this space there are some people who people call on all the time, but there are also so many other people that are doing really good work. I'm not throwing my brother under the bus, but Darrell Woods is a guy who you see every single time. And he has enough stuff on his plate, and I would hope he wouldn't just be that one individual because he's the one person we see every single time. So I'm curious how we're going to select in those two different instances, because they're different from the others.
Yeah, thank you, Rep. Young. So if you look, it starts with an individual appointed by a list of 3 names submitted by the director of the department, and then it goes on to list previously incarcerated criminologists, community corrections. So there's still 3 names, but it comes from the Michigan Department of Corrections.
Which version do you have?
Okay. Wrong version.
I'm sorry, Representative, what page what were you referring to? My apologies. Okay.
Near the bottom. When you look at how the names are selected, if we just start at the B line, 2 individuals, or, let me see here, a D.
D, okay.
Individual who, and when you go down, you have an option of selecting from 3 individuals, 3 different people, until you get to where it says, but there's one individual who was previously incarcerated.
Right.
And there's no option, there's just one person. And so I'm just curious to know, why did you change when there were 3 previous, and every other example? Until we
Yeah,
got
yeah.
there, until we got to the other one?
That's a good question. It just we identified certain organizations that have sort of an overarching group. So, for example, with the prosecuting attorneys, we have PAM, and as it relates to a formerly incarcerated individual, there is not one central organization that we could refer to that would, I think, justify selecting one specific organization over the other. So in that case, this would be a decision that the governor would be able to select an individual. Does that help clarify that point? Because I can't, I mean, it's hard to identify. There's plenty, to your point, there's Safe and Just, there's Michigan Liberation, there's several organizations that deal with a lot of formerly incarcerated individuals. To try to pinpoint one, I think would be difficult. Whereas, for example, the sheriffs, I mean, there's the Michigan Sheriffs Association, right? So there's that one central group that we can look to and then say that it would be, I think, a fair assessment on their recommendation, given that, you know, they're a centralized organization with really widespread membership.
I get that. I guess I'm still looking at it in the sense of some of those groups that you mentioned. That's what she's gonna have to go to. Whoever the governor is gonna have to go to some of these groups
Right.
and get those names. They're not gonna come out of hat. So that was the only thing that just kind of stuck out.
Yeah,
to me.
no, I think that's a fair point. And, you know, if it's something that. Got it. Thank you. Of course.
We do have some more questions, but I'll ask that members hold their questions. We will have an opportunity after these other folks testify to take questions, if you don't mind. And you may proceed at your pleasure.
I will just take a minute to introduce myself again and give a little history. I served in the legislature until 2014. This was the last bill package that I put forward in lame duck of the bill package. 2 bills passed. This was one of them. There was what I call kind of a poison pill in that bill that was a compromise, and that was to put a sunset on the commission, which I think was the reason that it failed. The members, some members that didn't want it, others that were opposed to it, just basically wrote out the clock on the commission, and it disappeared again. I just completely agree with Representative Anish. Boy, there's a blast from the past. Sorry. In moving this forward, it is so important, I believe, that when you exercise this kind of authority, this kind of power as a government to take away someone's freedom, that the experts should be weighing in. And Representative Filler, I respect what you're saying. Some good things have happened in the past 10 years. And we have seen a change in attitude on how we take away those freedoms and where it's appropriate. I just firmly believe that should be carved in stone, that we review it on a regular basis, and that the experts on both sides of this conversation be around a table to look at this. Frankly, I did not feel when I served up there, that I had the expertise. Now, I see a lot of law enforcement and lawyers that maybe you're far better at it than I was, but I didn't feel I had the expertise to impose a sentencing guideline on someone for a crime. And so often, we would see legislators come in, and it would be the easy bill, frankly, to get a PA on, is impose a sentencing guideline. Or if a constituent group or a constituent back home came and said, hey, this happened to me, therefore I want my pound of flesh, we would come up with a new sentencing and basically make something more illegal than it was already. And I think that's a wrong way to look at our criminal justice system. So thank you for bringing this up, Representative, and thank you, committee, for taking it up.
Good morning. My name is, again, Barbara Levine, and I was a member of the work group that Rep. Haveman put together to pass the Criminal Justice Policy Commission bill back in 2014, and then I was a member of that commission from 2015 through 2019 throughout its existence. So that's sort of what I bring to this. Before I make a few very brief remarks, I want to respond in addition to Representative Filler's question. He rightly pointed out a lot of things that are going on in the criminal justice system, a lot of them very positive. But the sentencing guidelines are also going on. This is about the guidelines. And the guidelines they've had ad hoc amendments by the legislature here and there over the years, but they haven't been systematically reviewed. And those set they set the bottom line when sentencing is going on. So the fact that the department has managed to reduce the population, that there may have been some positive changes in parole, that there may be changes in community corrections or specialty courts, those are all good, important things. But the guidelines are a thing in themselves, and they need to be reviewed to see the extent to which they're even being complied with, and what the effectiveness of the guidelines are. So that's what this is largely focused on. And the points I really want to make are three simple ones. First, an assessment of the guidelines is long overdue. A broadly representative commission is the best body to perform that assessment. And this bill really should be an easy call because it has no immediate impact, and it commits the legislature to no particular outcome. It merely establishes a process that could have important consequences down the road. So to each point very briefly, as to the need to assess the guidelines, when the current sentencing guidelines were developed by the original Sentencing Commission in the late 1990s, they were inevitably based on assumptions and educated guesses about what their impact would be. No one could know for sure at the outset how judges would apply the guidelines, what sentences would actually result, what the impact on correctional resources would be, or how a relevant body of law would develop on appeal. It was envisioned always, it was envisioned at the time, that that commission would stay in business, it would monitor the implementation of the guidelines. It would collect and analyze data and determine whether the underlying assumptions on which the guidelines were built had actually proven to be accurate. It would assess whether the legislature's goals in enacting the guidelines were being met and whether there were unintended consequences to be addressed. If needed, the commission would recommend modifications to the legislature. All that's really explicit in the enabling legislation for the original Guidelines Commission. But none of this happened. Once the guidelines were enacted, the original commission never met again. It was initially defunded, and then its enabling legislation was repealed. As a result, we have gone for 25 years without any systematic analysis of how effectively the guidelines are serving their intended purpose. We came close. In 2014, Rep. Haveman convened a work group that resulted in the Criminal Justice Policy Commission. That work group was very diverse. It included stakeholders who rarely saw eye to eye on anything. But the need to assess the guidelines was so apparent that the group's support for establishing the CJPC was unanimous. And the enabling legislation, as I recall, passed with bipartisan support. Unfortunately, for a whole variety of reasons, the CJPC didn't complete its task before it reached its sunset. Notably, every stakeholder represented on the commission supported extending the sunset, but that didn't happen either. So here we are with the work still remaining to be done. Second, a new commission is still what's needed. Developing sentencing guidelines is a complex process. You're talking about deciding what a reasonable presumptive sentence would be for every crime in the penal code, and then deciding when and to what extent judges can make sentences longer or shorter than that presumption, depending on the facts of the individual case. There's a lot of very detailed work to be done that requires familiarity with how the guidelines work, thoughtful consideration of the various policy issues laid out in the legislation, and access to data about such matters as current average sentences, recidivism rates, and the extent to which judges follow the guidelines recommendations or depart from them. It takes staff with the capacity to do the statistical analyses of the data, to model the outcomes of potential changes, and to research best practices from other jurisdictions. This is not work that can be done effectively by a legislative committee. It takes time, and that's why, as you will hear from Mr. Reynolds, other sentencing guideline jurisdictions generally have commissions, staffed commissions that sit continuously to do the work. But in Michigan, ultimately, the commission's product goes to you. You can adopt it, amend it, or send it back for more work. The commission is meant to have influence as the result of its effort, integrity, expertise, and broad stakeholder representation. But its only power is the power to persuade you to agree with it. Finally, this bill really should be, I think, an easy call. It doesn't change the current guidelines in any way. It merely sets up a process for considering whether to change them. You're not committing to any particular outcome. There's no way to know now where the evidence will lead and what a commission might ultimately recommend. But what we do know is that sentencing involves the most critical functions of government: protecting public safety, being fair and cautious in restricting individual liberty, and spending billions of taxpayer dollars annually. Now that we have decades worth of data available to us, it is time to determine just how well these functions are being performed and whether there are ways to do better.
Thank you. Before we turn to Mr. Reynolds, I did want to give the bill sponsors an opportunity to talk about the makeup of the commission and how it may ultimately be different than the bill we have before us right now.
Yeah, and I want to apologize to Representative Meerman. He was looking at the draft that would have had those changes. So we've had conversations with law enforcement and victim advocates, and there's going to be a change from what you're seeing now. There will be the removal of one person, the nomination for the Michigan Association of Counties, and a reduction of criminologists. I'm fasting, forgive me. From 2 to 1, and then replacing those two individuals will be a circuit court judge and a police chief. So we're adding 2 victim advocates and changing up the makeup from there. So other than that, everything else you see in the bill will be as is, but I would defer to you, Madam Chair, in terms of when the substitute would be adopted, and we'll give you ample time to obviously look through that. So again, I want to apologize because Rep. Meerman was sort of ahead of the curve there, and which is why the lines were a little bit off. Representative Young.
Thank you. And I still have your names down if you had a question, but we will turn to Mr. Reynolds on Zoom.
Thank you, Madam Chair. Members, my name is Carl Reynolds. I'm with the Council of State Government's Justice Center. I'm the Senior Legal and Policy Advisor. I'm coming to you from Austin, Texas, from my home office, and I really appreciate the opportunity to testify virtually. The Council of State Government's Justice Center is a national nonprofit, nonpartisan organization that combines the power of a membership association with policy and research expertise to develop strategies that increase public safety and strengthen communities. I wanted to talk about just 3 points that are relevant to this bill. One is about other states. One is about the history of sentencing, a kind of unique, notable history of sentencing in Michigan. And then finally, a little bit about the project that I led in 2013 and 2014, which was a very deep dive into the workings of your sentencing system that yielded all kinds of interesting analysis and included the recommendation that Michigan really needs to have a sentencing commission to carry that kind of work forward. So backing up to other states, 25 states or more have a sentencing commission. There are 22 states that currently participate in the National Association of Sentencing Commissions. And by the way, I'm on the executive committee of the NASC, the National Association, deeply involved in the work of sentencing commissions around the country. There are at least 3 more states that I'm aware of that have serious sentencing studies underway. California, Colorado, and New Jersey are all involved in some pretty interesting work on sentencing without having the formal label of a sentencing commission. And every state that has actual sentencing guidelines, except Michigan, has a functioning commission. As a resource, I would really point you to the Robina Institute. They have a wealth of information, including profiles of all the sentencing guidelines states, including Michigan. And I will send, I'm going to make reference to a couple of things that have web links, and I'll send those to the clerk so that members can see those. And then finally, with regard to other states, I would urge you to think about looking at Pennsylvania as a really interesting sort of example of a very strong sentencing commission staff housed in the legislative branch, as this proposal would do, and with remarkable university partnerships that really strengthen the work and the research that the Sentencing Commission does. Pennsylvania is kind of at the opposite end of the spectrum from Michigan in that they have a well-staffed, highly functioning sentencing commission that's been around for decades. And so as an aspirational model, I'm not saying you should try to get to Pennsylvania right away. It is at the opposite end of the spectrum from a state with guidelines and no commission, but they do remarkable work, and in a state that is in some ways quite comparable to Michigan in terms of population and urban-rural dynamics and so forth. Second, I want to say a little bit about Michigan's notable sentencing history that goes all the way back to the beginning of the last century. In the early 1900s, your Constitution was amended to allow for indeterminate sentencing. It has the phrase indeterminate sentencing in the Constitution, which may be unique. And a law was passed right after that. It's still on the books, MCL 769.8. It says the maximum of every sentence is set by law and shall be stated at sentencing. So whatever the guidelines say about the minimum, the maximum is always going to be the maximum set by law, which creates an enormous amount of indeterminacy in your system. Fast forward 1972, the Tanner case came down where your Supreme Court basically said that indeterminacy means that the minimum can't eat up the maximum. You can't set a minimum that's just up to the borderline of the maximum because that's not an indeterminate sentence. And that change was later on adopted by the legislature as a rule in the books. 1979, there was a report of the Michigan Felony Sentencing Project that ultimately led to judicial guidelines being adopted in 1983. 1994, the Sentencing Commission was first created by the legislature, and in 1998, as Ms. Levine alluded, PA 317 was enacted, which was the legislative guidelines that still exist. And as I understand it, they were tie-barred or otherwise closely linked to the notion that there would be truth in sentencing for those minimum sentences. 2002, the commission was formally disbanded. It had withered away long before that. And then 2004, the National Center for State Courts did a study of sentencing in Michigan. And that was the last time that a concerted look was taken at sentencing until we came along. In 2013 and 14, the Council of State Governments was asked to do a sentencing and justice reinvestment project. And this is the third thing I wanted to mention to you all. One of the 7 policy options that we advanced was Michigan needs to monitor changes to the state's sentencing practices along with their impact, and it should establish a body and standards to independently and collaboratively monitor sentencing and system performance. The extensive analysis that my research colleagues did of your system is well worth taking a look back, and I will share this link with you. I really encourage people that are interested in Michigan sentencing to look at all the things that we observed through data analysis about the way your system works, and think about the fact that analysis serves as an example of the kind of thing that you should be coming to expect, that a sentencing commission should be able to do that sort of analysis of what's happening in your system at a very nuanced level, as we were able to do. So as I say, I'll send the link to those documents to the clerk, and I would encourage you to look at those. For all those reasons, I think, in my opinion, and I'm a big fan of the existence of sentencing commissions, of interdisciplinary collaborative bodies that are using data analysis to understand what's happening at this most important juncture in the criminal justice process, the point at which the judicial branch is convicting someone and giving them a sentence and handing them over to the executive branch to carry out that sentence. It is just a fundamental piece of what happens, and a deep understanding, transparency about how that works is vitally important. That's all my testimony. I appreciate, again, the opportunity to be with you.
Thank you. And now for member questions, Representative Breen.
Thank you, Madam Chair. I support the creation of this. I think it's important to note Michigan sentences are almost double that of the national average. We need to look at why. We need to look at recidivism rates. We do have treatment courts, and as Representative Filler put out, other successful programs, but we need to determine what it is about Michigan that leads to these longer sentences and figure out why they are or are not appropriate. We have racial disparities to consider. There's an economic argument, of course. It's like 34 to 48 grand a year, not including medical, to incarcerate someone. I am a lawyer. I do not have a criminal justice background, but I know there's going to be questions about truth in sentencing. And I'm wondering if somebody here can explain how and why this does or does not conflict with the truth in sentencing provisions that we currently have in law.
I can take that. Truth in sentencing was tie-barred to the original sentencing guidelines back in the 90s. But what truth in sentencing does is eliminate what used to be called good time and subsequently renamed disciplinary credits, but it's credit for good behavior. Other jurisdictions also have, in addition or instead of time off for good behavior, earned credits that award time off from the minimum sentence for program participation or work or other sorts of positive activities in prison. So the notion of truth in sentencing is you get a minimum sentence, whatever judge gives you after referring to the guidelines. But then there's no administratively taken time off that minimum sentence. You serve every day of that minimum under our current truth in sentencing scheme. And that's the result of separate legislation, and it wasn't contemplated it's not an inherently necessary part of looking at sentencing guidelines, other than keeping in mind that whatever minimum the judge picks, that's going to be served. It's not going to be reduced. So there was a time when good time was very generous, when judges could give very long sentences that looked very tough, knowing that the prisoner had control over how much of that he or she would actually serve, because the longer they serve, the more time off that minimum they'd get. That doesn't happen anymore. And the latest version of the bill explicitly takes consideration of truth in sentencing out of the commission's realm. A lot of people support restoring good time credits for a whole variety of reasons, including internal management of the prisons, as well as having some sort of positive rewards. But it's a separate issue, and people can pursue that or not, but it's not an inherent part of sentencing guidelines.
So I just want to make sure I understand this correctly. The commission will essentially help set the standards, and truth in sentencing is to make sure that those standards are met.
So I just want to be very clear, Representative. The substitute will be very explicit, and this will not touch the truth in sentencing component of this. So
Okay.
the commission is not going to talk about good time credits. It's not going to give recommendations on any of that stuff. It's sort of left that aside in the final version of the bill. So we have explicit language in the substitute that will clearly outline that.
Thank you.
Yeah.
Representative Arbit was next, but it looks like he may have stepped out. Representative Harris.
Thank you, Madam Chair. So with this commission, who is anticipated to staff it at this time?
Once the commission is established, we are gonna, the second part of this is looking at getting funding to make sure that we have experts that will be working alongside the commission to get this done.
So no one's been selected as chair at this time?
No, there's no commission right now.
Okay.
Representative Begol.
Thank you, Madam Chair. I noticed the bill on page 5 talks about working with the State Court Administrator's Office to collect, analyze, and compile certain data regarding caseloads and docket flow of trial and appellate courts. My question is there a reason why the State Court Administrator is not capable of performing that task without assistance of this new bureaucracy? It just seems to me there's a lot of effort being duplicated.
Is your question along the lines of what's being done here? Because you're suggesting it's already being done?
Yeah, I see a lot of that throughout the bill, but why the State Court Administrator's Office in particular would need the assistance of the commission? I could couple that with the appellate courts often review some of these sentences too to be sure that the trial courts are following and doing what they're supposed to be doing. So I'm just wondering how about the duplication of that effort as well.
Yeah, in my mind, the idea here is to help this commission understand what's going on and give them the information they need.
And Representative Begol, this would, again, it would centralize. There's a lot of components when we look at sentencing guidelines, right? It's if you sort of keep it in a fragmented fashion, it becomes difficult, I think, to provide comprehensive recommendations for the legislature to then act. So this would allow the commission, given the breadth of the experts in what fields and areas that they come from, to be able to look at this data in one centralized way. Whereas if you're sort of looking at it fragmented, to your point, this court looks at it this way, and other groups look at it in other ways. This would just allow the commission to be able to look over this and then give recommendations in a centralized way rather than it being all over the place.
If I can follow up on that for 1 second, you'll also see that there's a provision that addresses cooperation with the MDOC, which also has its own research division. The courts collect data for their own purposes on how the trial courts are operating, how they're processing their caseloads. The DOC does an enormous amount of research on the corrections population. The purpose, I think, of these two provisions is simply for the commission to be able to connect with those two entities, utilize the data that they collect for their own purposes, and connect it to sentencing guidelines to see what the impact of the guidelines specifically is on DOC populations and trial level court operations. So it's not duplicating those efforts. It's, as the representative indicated, it's simply trying to
streamline it,
incorporate, collect all the data that's relevant to the operation of the guidelines themselves.
Representative Filler.
Thanks, Chair. Just the way I read this bill is, and the way I hear this testimony, I feel like there's a belief that sentences are too high in the state of Michigan from pretty much everybody involved in the drafting and support of this bill. And also when I read some of the things that go into this, a lot of discussion about diversion instead of prison, so jail instead of prison. So I guess my question would be, which prison sentences are too high? Is it CSC? Is it assault and battery? Is it human trafficking? I mean, which ones are too high?
To speak to the first point first, I think
because, and I'm sorry, Rep. I left an important part of it. If the purpose is to lower sentences, I mean, why don't you just put the bill forward to lower sentences in the state of Michigan?
Did you want
Go ahead.
Okay. Well, no. The purpose of the bill is to set the commission up. I don't know personally. I mean, I'm a representative in the legislature.
You don't believe prison sentences are too high in the state of Michigan?
I'm saying that I don't have the expertise to make an informed opinion on that matter. So what I'm saying is I do think we have to do something personally. You know, my political inclination is to say we probably might have to reassess some of our prison sentences. But I'm not in a place where I can say that and introduce legislation without leaning on the experts. For all we know, the experts can come back, the commission say, hey, we actually need to increase sentence times. I'm not sure because I'm not going to serve on that commission. This is simply to allow them to lean on the experts. It allows them to lean on folks that are directly involved in sentencing to be able to give us an analysis of, hey, does this make sense? And again, it's been 30 years. Just to give you, I'm going to go back to the two examples that I brought up. The way we look at drug crimes, right? We see a lot of diversion and things of that nature to sort of reduce or reassess some of those examples. A lot has changed since the 90s from today around drug crimes. Another example is...
I think we both would argue that probably, I guess, if there was a marijuana I mean, it's not even applicable anymore, right? But that strikes me. You could drop that bill tomorrow, and I'd probably sign off on it because marijuana is legal in the state of Michigan. Yeah. I just don't see a need for a whole commission on something that you and I probably...
No, you're fine. I mean, the reality is there's so much to sort of look at. Another example is domestic violence, right? We, I think, maybe in the 90s, maybe have underestimated the level of impact and this severity of domestic violence disputes and issues, and perhaps that needs to be reassessed. I'm just here to say that I'm not sure what that reassessment would look like. I think we have less than 20 attorneys in the Michigan legislature, and even less if you look at the number who actually do and work in criminal justice. I know the representative from Novi made it clear that she's not a criminal attorney, right, criminal defense attorney, but she is an attorney. Now, does that mean that she has the expertise to sort of bring up all the ideas? I'm not sure, right? The commission will. If you look at the composition, who's going to be there, the experts that will be at the table to help look at the research, to look at the data, and it would simply say, based on our findings, this is what we think the legislature could do, but it certainly doesn't impose that we have to enact any of the recommendations that they bring up. And to your point, like I said, there could be a situation where they come back and say, hey, representatives, senators, you guys probably look at increasing sentences on some of these points or things of that nature. I just don't know. And, in the era of ChatGPT and sort of the AI component.
Ayash, I'm sorry to interrupt you, but we do have a couple more questions.
I
and
apologize.
We have a hard stop at 10:15.
I apologize.
Please continue your conversation offline. Representative Devendorf.
Okay, I just wanted to close that out by reminding us all that all commissions exist for the purpose of doing further research, consolidating all of the experts, making sure that we're using best practices, making sure we're not reinventing the wheel, making sure that we're not overlapping efforts. This commission exists for the same reason that we create just about every other commission. It needs to be created because there is a whole world of work right now that is being done on criminal justice reform and on prison reform, and it is incredible work. It is going to be very positive. It's going to bring us into the modern age, and it is absolutely necessary in order for us to continue to do criminal justice in a humane way. So we are bringing all of these folks together in order to make sure that we are not duplicating efforts, to make sure that we are bringing in the folks who have the best practices, because we are right now working in silos out of sheer enthusiasm and intent to make sure that we do this. So we need to do it the right way. The same reason we would create, and we do create, and that we have so many other commissions. That's it.
Representative Sterniglu, if you can be really quick.
Thank you. I just want to say I actually am a former defense attorney. I'm also a former victims advocate, and I served on the county board with Chair Hope. And all of those are different perspectives. And I wholeheartedly support your effort here, not because I think we need lower sentences on all crimes, but I think on some crimes we need higher sentences, and on some crimes we need lower sentences. And I think that we need a group of all of those stakeholders, including groups like sheriffs and prosecutors, so they can all look at that together, see what works, what's needed, how do we go from here. I think it's a misconception that this is a way to just lower all sentences. On the county board, I chaired the Law and Courts Committee, and one of our issues was jail overcrowding. So we need to make sure we have the right people in jail, that that's going to serve a purpose, and not the wrong people. And a lot of that goes along with the sentencing guidelines. So I just wanted to kind of put that out there, and thank you, for your work on this, because this is a way to make us all safer as a state, and just and also sometimes funding becomes an issue. And so that's something to look at as well. And I think that will also address
Rob.
that. Thank you.
Thank
Sorry.
you. We do have cards for the minutes that will be recorded, and I thank you for your testimony. Thank you. With no further business, we are adjourned.